Donald Trump wants a trial scheduled, and he wants it done reasonably during a time frame that is responsible, which happens to be 2026. Now, we know the election is in 2024, so a couple years after the election seems about right. People on the left are laughing about this, kind of screeching and shouting, going, oh, 2026. What's like the midterms? Yeah, after Donald Trump has won, and after the first 2 years of his successful presidency, yeah, then we can have a trial and see how it goes. But the point is, there are 11.5 million documents, give or take, the government is still assembling it all, that they say is part of discovery that needs to be delivered over to Donald Trump and his defense team. And so his defense team put together a brilliant memo. It's got charts and graphs and numbers and all sorts of stuff. This is the response. 16 pages. We got some charts and graphs. It's beautiful. In the United States District Court, this is the DC case. We're talking about January 6th. Government versus Donald Trump. This is Trump's response. So Trump is responding to the government's proposed trial calendar, and it's in opposition, right? Remember, the government said we could get this done like lickety-split. We'll have a trial immediately, and I think they said that the trial would start, according to them, they said opening arguments, they wanted it to start in January of 2024, with jury selection being picked and voir dire taking place in December. So Trump is saying, no, how about no? Trump, through his lawyers, respond in opposition to the original request, and here's what they say. They open up with a quote, referenced from a 1932 case from the United States Supreme Court called Powell versus State of Alabama. The prompt disposition of criminal cases is to be commended and encouraged. But in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. To do that is not to proceed promptly in the calm spirit of regulated justice, but to go forward with the haste of the mob. United States Supreme Court, 1932. Slow down, lest we become part of the mob. Trump's defense says, this is an unprecedented case in American history. The incumbent administration, Biden, has targeted its primary political opponent and leading candidate in the upcoming presidential election with criminal prosecution. The administration has devoted tens of millions of dollars to this effort, creating a special counsel's office with dozens of employees, many of whom are apparently assigned full-time to this case, in this case alone. Taking full advantage of the administration's blank check, footnote 1, referencing the DOJ expenditure report, reporting $5.4 million in direct expenditures, another $3.8 million in DOJ components. Lots of money being dumped into this. And remember, Trump has to come and meet this. He's got to hire his lawyers, and they've got to hire their staff. So it's draining his resources that could be used for campaigning. All intentional. And this doesn't cost them anything, because you know who's paying for this? Spent over 2.5 years investigating this matter. It, among other things, interviewed and subpoenaed hundreds of witnesses, executed over 40 search warrants, compiled information from countless individual sources. Trump's team says the government included some, but not all, of the materials in a massive 8.5 terabyte initial production, totaling over 11.5 million pages, together with native files, recordings, and other electronic data not amenable to pagination. So we don't even know how many pages it is. In this district, Judge, ordinary order, when faced with such overwhelming discovery, is to set a reasonable trial schedule, commensurate with the size and the scope of discovery and complexity of the legal issues. The government rejects Biden's special counsel, rejects this sensible approach. Instead, they seek a trial calendar more rapid than most no-document misdemeanors, requesting just 4 months from the beginning of discovery to jury selection happening in December. Jack Smith and Biden's objective are clear: to deny President Trump and his counsel a fair ability to prepare for trial. The court should deny the government's request. They say the public interest lies in justice and fair trial, not a rush to judgment. And moreover, if the rights to due process and counsel are to mean anything, a defendant must have adequate time to defend himself. The Speedy Trial Act embraces these considerations, and so too should the court. Accordingly, President Trump, Your Honor, respectfully requests the court schedule this case to begin on the April 2026 trial calendar. 26, with the following interim control dates. The week of December 4th, 2023, a discovery and status conference with a motions hearing. Then we'll fast forward to April, another quarter, another discovery status conference. We'll jump out to August 2024. Then we have discovery status and other motions, and you can see that it just goes on, right? A lot of motions hearings. So we'll hit the dates. August 1st, August 22nd. So it looks like 2 updates in August, 3 updates in August. August 5th. Then we have September. We've got other motions, another motions hearing, more discovery status conferences. So basically what they're asking for, I believe, is they want the judge to check in on them, to say, okay, how many millions of pages have you done? Right? These are basically all the same thing. Status conference, motion, status conference, motions. The way this will work is, think of it like a process where the government delivers a batch of files. They say, hey, this is our batch 1. You say, okay, cool, let me take a look at it. What do you say is in batch 1? They say, here's what's in batch 1. It's officer A, B, and C. So, okay, great. We got batch 1, officer A, B, and C. We say, okay, all right? But this references Officer W. And so we're going to need Officer W. And also, you also reference this report. So we're going to need this report and this report based on what we found in your batch 1. So what we're going to need are supplemental filings. So we want all of this other stuff. So just think of all the branches that come off just from one batch, right? You say, okay, you've got this. We need Officer A's background. Apparently he was disciplined in this. We need his personnel file. We need this, blah, 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 and so on and so forth. And then they say, no, you don't get that. No, we're not going to give you this branch or this branch or this branch. We already gave you what we felt was conclusive. We know about that. We know about that. We know about that. But we're not giving it to you because it's outside the scope of the case. And the defense says, the heck it is. So we need it. And we need to talk to the judge about this. So see you in court. So that's this process. Okay. It's like this little roundabout, this circular thing that happens. There's a delivery. There's a request for supplements. There's probably a battle over it. The judge will decide it and you'll do it again. So that's what's happening here. A status conference and a motions hearing so that when they say, hey, we need this thing, the judge can deal with it. And that process will go around and around again. So, in 2024, they'll come back and they'll say, yeah, we got through about 2 million pages, give or take 2 million. Wow. All right. I'll get back to it. So they come back August 4th. How many more pages did you get through? Oh, judge, man, it's been a long time. All right. August 4th. It's been like months now. December is our next status. Okay. So we've got a full year. We did another 2 million. So maybe it's 2 million to get to 11. We're going to need to go a lot faster than that. So we're going to need to break it down, right? You do the math, the calculations, but 3-4 million a year until we get to 2026 and just do the calculations on it. So then we get to our final pretrial conference in March 2026. Maybe they'll give us some breakdown of what they intend to do, but you get the point. All right, we'll do 3 million here, 3 million here, 3 million here, and updates the entire time. Now, motions in limine are the more substantive motions. That's to say, all right, well, based on the discovery, we don't want this witness to be able to testify. Based upon this evidence that they've given to us, we don't think that this issue should even be discussed. And so then we're having this battle, and this is all taking place, like this section is right before trial. So April is when jury selection would start. The rest of this is hearings, motions in limine, all the preliminary motions. But the rest of this is just that discovery circle and arguing over discovery as we go through 11 million documents, plus the videos, plus the non-paginated documents, and so on. So you see, like that seems a lot more reasonable because it's hard to go through 11 million documents in 4 months, right? Because that's like 2.5 million documents a month. Divide 2.5 million by 30 days. I don't know what that is. So they say, Your Honor, obviously, this is a more reasonable schedule, equal to the government's time spent investigating the matter. And it's going to allow this case to proceed in an orderly fashion with both parties having a fair opportunity to review all the material, advance the appropriate motions, apprise the court of relevant legal issues, and additionally, Trump's proposed schedule will do the following. It's going to avoid scheduling conflicts with other things, give us plenty of time. We've got other prosecutions brought by this corrupt government. We also have to provide sufficient time to address the production of the discovery under the CIPA rules, because they did acknowledge that there was a small batch of classified materials even in this case. And 3, to preserve Trump's right to seek discovery from third parties, right? Because he might want to go send some record requests over to the DOJ or to, let's say, the Capitol Hill Police or the Metro Police, or maybe he wants to go dig into some other allegations in other states. He says, while also addressing significant gaps in the government's production. So they say, Your Honor, at this early stage, without having reviewed the discovery, President Trump cannot estimate the time that he's going to require to present the case at trial. However, for the present, without any waiver of rights or arguments, when we actually get to trial in April 2026, President Trump will adopt the same calculation as the government. 4 to 6 weeks for the defense case. Maybe a month and a half for the government. 6 weeks, they present their case. Trump gets his own 6 weeks for the defense, they say. In setting a trial date, Your Honor, a court must allow Trump and Trump's lawyers, quote, reasonable time to prepare, because stripping away the opportunity to prepare for trial is tantamount to denying altogether the assistance of counsel for the defense. And for that reason, the Speedy Trial Act, which oftentimes, right, this feels a little bit strange because sometimes you'll see the defense wants a trial done quickly. The Speedy Trial Act directs the court to consider the unusual or complex nature of the case, and then the need to provide lawyers for the defendant, in this case Trump, reasonable time necessary to prepare for effective preparation, also taking into the account the exercise of due diligence. That's the code. Whether a delay is reasonable, whether this is justified, depends on a lot of things. How long did the Ghislaine Maxwell case take? The length of the requested delay, whether other continuance have been requested or granted, the balance, convenience or inconvenience of the litigants, counsel, whether the requested delay is for legitimate reasons or whether it's dilatory, whether the defendant contributed to the circumstance which gives rise to the request for continuance, whether they were competent counsel or here, and so on. All of these are various factors. They say, Your Honor, we also appreciate the heavy caseloads that the courts are under, and we understand how you're operating and your interest in expediting trials. We feel compelled, though, Judge, to caution caution against the potential dangers of haste and to reiterate that an insistence upon expeditiousness in some cases renders the right to defend with counsel an empty formality. We're going to have some constitutional problems if we go too fast here. In our system of justice, the Sixth Amendment's guarantee to assistance of counsel is paramount, ensuring the fundamental human rights of life and liberty. They say the Sixth Amendment stands as constant admonition that if the constitutional safeguards it provides be lost, justice will not still be done. So here's the argument. Your Honor, this is why we need to bump this thing all the way to 2026. 11.5 million pages is a difficult number to comprehend. Ordinarily, a complex, document-intensive criminal case might have maybe 1 million pages at issue. They say here was one example, U.S. versus Scarfo. This was an open-ended continuance, and this was a complex case designation under the law. There were 1 million pages of information in that case. Open-ended, it was designated complex, which means it took a lot longer under the code. If you designate a case complex, you get a lot more time. To have over 10 times that many pages at issue against one defendant, Trump, is largely unheard of. Such cases are instead almost always sprawling civil battles between large companies, which regularly take years to litigate. Here's one example. Walmart versus Visa. That took 7 years to litigate, and guess how many documents that case took? 5 million pages of discovery in Walmart versus Visa. But they want to try this case in January of next year. It took 7 years to litigate that one. They say, to put things in perspective, Your Honor, to put 11.5 million pages in context, we began downloading the government's initial production on August 13th, 2023. 2 days later, it was still downloaded. We then requested the government send hard drives containing its initial production, which we received on August 16th. Our technology vendor is now preparing to ingest the files into a document review database, but estimates that such a large data set will take several days to process. Nonetheless, even assuming we could begin reviewing the documents today, we would need to proceed at a pace, there it is, I was hoping somebody did the math, save me, 99,762 pages per day to finish the government's initial production by its proposed date for jury selection. That's some serious speed reading. That is the entirety of Tolstoy's War and Peace, cover to cover. 78 times a day, every day, from now until jury selection. Cover to cover, 78 times a day, every day, from now until jury selection. A lot of reading. Keeping in mind, this is just to read the government's initial production a single time, to say nothing of trial counsel's need to analyze, organize, integrate those materials into a cohesive defense presentation. Meaning you've got to analyze this stuff. You've got to read it. You've got to ingest it. You've got to take notes on it, discuss it. You don't read a police report in a criminal case also one time. That's nuts. You have a lawyer who just flips through a police report one time and reads it and you're just done with it? No, of course. You're preparing for trial, you're reading it multiple times, you're doing interviews, and then you're cross-referencing the interview with the report. You go back to the report many times. Oh, what did you say? You said this, but you said this now. Okay, you go back times millions of pages. It's insane. Trump's team says, stated differently, if we were to print and stack 11.5 million pages of documents with no gap between pages at 200 pages per inch, the result would be a tower of paper stretching nearly 5,000 feet into the sky. They've got graphs. Look, they have the Statute of Liberty, 305 feet. The Washington Monument, 555 feet. Information potentially helpful to President Trump, 4,822 feet. Yeah, baby. Look how ridiculous this is. This is paginated portion of this is just the initial production, by the way. This is 200 pages per inch. So if you get so somebody got a ruler out and said 200 pages is about 1 inch times 11.5 million pages is 5,000 feet. It's multiple Washington monuments. I mean, look at these. Like, that's another Washington. That's a Washington monument. We've got, like, I don't know how many you can fit in there. I mean, that is a lot of Washington monuments. That's a lot of Washington monument evidence. He did try to insurrect the country. I mean, maybe is that was he trying to take the National Archives with him? They say that is taller than the Washington Monument, stacked 8 times. They did the math. Thank you. Stacked on top of itself 8 times with nearly 250,000 pages to spare. All right. So absolutely hysterical. Information that's potentially helpful to President Trump and their disclosure. It's 7 Washington monuments plus the original. They say, okay, look, even if this analogy belies the true scope of discovery, it includes only printed text without considering native files, We don't even have audio recordings, phone and electronic device image files, and other materials that will require substantial labor-intensive review. Government is already describing hundreds of recordings of witnesses. They describe a hard drive with various returns and extractions that they say are impossible to paginate. So we don't even know, we don't know what the extent of this actual data is because we can't even quantify it. There's no measuring stick to it. Like, how many hours of video are they just scanned, limitless, borderless files that just have odd ends and sizes in their scanning? What's in there? We don't even know. Logs, right? Just logs with Excel spreadsheets that go on for 50,000 rows that have GPS records or something like that. Just gobbledygook that they just spit out from some device. They say, likewise, it does not consider the large number of additional documents also, by the way, the 8 Washington monuments that the government has not but still intends to produce. So it could be 20 Washington monuments. We anticipate additional productions in the coming weeks, and our goal is to have discovery substantially complete by August 28th. They say the government is also going to obtain more going forward. We're going to continue then to produce on the defense on a prompt rolling basis more Washington monuments. We use the term wheelbarrow here, right? I used to say wheelbarrow all the time, they would just dump a wheelbarrow full of garbage in your front. Not even close. An order of multiple orders of magnitudes different. It's not even close to a wheelbarrow. It's a Washington monument, all right? That's how nuts this is. And a wheelbarrow would be nuts. So President Trump may request from the government in discovery, meaning that Trump's going to look at the monuments and then say, I need more. I need an Empire State Building, and I need a Pentagon. I need a Pentagon, I need a Homeland Security, I need an FBI, and I need a DHS. Send them over. Put them behind the Washington Monument and the Capitol building. All right. So he's going to ask all this stuff, and he may make requests for that stuff. They say Trump may also make requests from third parties. For its part, the government suggests that it has, quote, prepared and organized discovery in a manner that will assist Trump in his review of the produced materials. Which I just love. They're quoting them. It's okay, setting aside the dubious accuracy of this statement, prosecutorial organization of information cannot solve the defense's largest burden, which is reviewing the documents and preparing to use them at trial. Thanks, guys, for your sticky notes. That takes time. A lot of time in this instance, regardless of how the documents are labeled. Similarly, the government claims that it will provide a compilation of certain key documents and identify certain material within the discovery that is, quote, arguably favorable to the defendant. And we lampoon this when they wrote it. I couldn't even believe they wrote it. It's oh, thanks. That's great. This again is no answer. The government's view of importance surely differs substantially from the defense. And it goes without saying that a criminal defendant should not build his case on the word of his accusers. Idiots. What kind of even argument was that? We helped you though. It's nice and organized with little sticky notes and labels, and it's color coded. And we can't wait to execute you rotten hell. Oh, thanks for this. Yeah, we're going to use it. All of our defenses. Thanks. Have a great weekend. Rather, President Trump has a right to review all the material information regardless of the government's view of the significance of such information to the defense. This is a critically important process, as identifying and presenting Brady material, which is material that might exonerate Trump, will be central to demonstrating President Trump's innocence. Referencing another case saying the right to present favorable evidence to the jury is clearly established by the Supreme Court. And the government's in a little bit of a pickle here because they can't unring this bell. We already know there's 11.5 million pages. We already know they said that's not all of it. We already, so they can't come back and say, oh yeah, you're right. Sorry, we didn't look up Walmart versus Visa and realize this was double that. We didn't recognize 8 Washington monuments full of literal physical paper. Okay, 8 Washington monuments of physical paper. And what we meant was it's only 500,000 now. We say, oh no. That's 11.5 million plus some. So get it all over to us. They say we anticipate seeking leave to issue multiple subpoenas. By way of just one example, we would request a subpoena directed at the House of Representatives for documents related to the investigation by the January 6th Select Committee. Oh, yes! That feels good. Let's read that one more time. By way of just one example, Judge, we would request a subpoena to Liz Cheney and Brian Kinzinger's fake, illegally constituted Select Committee for documents related to their so-called investigation. We will also need to address the reported destruction of those documents by that committee, a story we covered here, which was an exchange between a House representative and Benny Thompson, who basically confirmed he sent this stuff over to NARA, to the executive branch, prior to documenting it it with the House Archives Committee, which would be potentially exonerative to President Trump. Love that. The government, which investigated this case, destroyed evidence, and that is exonerative to Trump. Even by its own terms, the government states only that it will identify certain, but not all documents it views as significant to its case or favorable to the defense. They acknowledge they might help us here and they might flag this for you and this for you, but not all of it, because they can't make that acknowledgement. They can't say we got everything for you. You know, that's kind of them taking ownership of it. Obviously, they're not going to do that. Thus, whatever limited usefulness the government's key document folder might provide, they say we batched it all and put it in a little index for you, it is not going to alter President Trump's need to fully review all discovery, all 11.5 million pages, multiple times. Additionally, in cases such as this, with substantial discovery, the court may require that the government to go beyond identifying certain key documents. Right. And the government might be forced to go identify more. It stands as no small irony, they say, that the government seeks to deny Trump his constitutional rights in a prosecution where the government wrongly alleges Trump violated the rights of others. Yeah, it's very interesting how that works, isn't it? Trump's team says, simply put, Your Honor, the discovery in this case is enormous and growing. Although Trump's team will, of course, work diligently to review this material, the process will take some time. For example, even under our proposed schedule, we would need to review approximately 12,000 pages per day to complete a first pass of the initial production by our proposed trial date. 12,000 pages per day. This is an exceedingly rapid pace by any measure, and one that will only be manageable with intense diligence. The government's proposal, by contrast, is just flatly impossible. No defendant can reasonably review 100,000 pages of discovery per day. Thus, even exercising, quote, due diligence, the government's proposal would deny President Trump reasonable time necessary for effective preparation, and in doing so, violates his rights to due process and to counsel. Citing other cases here, this one, 2020, 2014, DC Circuit. That looks like it's another DC Circuit case. This was a case affirming a continuance, a postponement, in part on the complexity of the case and the volume of discovery. The district court found that the defense itself is not going to be in a position without the additional time. The defense team notes, they say, the government contends that President Trump has been, quote, that Trump had been aware of certain relevant information made through hearings and the report written by the House Select Committee to investigate the J6 attack, and therefore should not need to thoroughly review discovery. So this is incredible. That's right. They did reference the committee. My one thought was maybe the government would respond to this and say Trump shouldn't get the subpoena for the J6 committee because the J6 committee is not a part of this investigation. This investigation came from Jack Smith. Jack Smith got the evidence on his own. He got it independently. He didn't get it from the J6 committee, and therefore Trump shouldn't have the right to subpoena for evidence that's not relevant, that's not used in the government, right? I know that's kind of a stretch. I would still argue he should get it, but I'm saying what's the counterattack? So then Trump says, I need that, but Jack Smith says, I already got it independently, so you don't get access to that. Now here though, the counter to that is that the prosecutors reference the January 6th committee. They say, no, you should just go over there and get it from them. And we also know that the January 6th Select Committee made a referral over to the DOJ. Okay, so they made a handoff. Then they deleted evidence, which could possibly be exculpatory, or we think they deleted evidence. That's what Benny Thompson says. They turned it over and it didn't go through the proper mechanisms and it might not be there anymore. So the government has included, they've lassoed in the January 6th Select Committee by referencing Trump to go get discovery from them, which is why he doesn't need as much time. So they've actually said that he needs to go get it from them because there isn't enough time to do it independently, right? So he has no choice but to get it from them, or should have been watching it, and so on. They have, intertwined themselves in a messy way here. The government simultaneously advises only a relatively small percentage of the discovery is non-sensitive, as only non-public material may be marked sensitive. That means Trump had no meaningful ability to review the government's discovery prior to production. This is really good work. That's right. They did say that. They said that it was sensitive in their protective order. They are twisting themselves into a pretzel. They said that Trump needed to go get the relevant discovery from the J6 committee, but most of the discovery that they're providing to him is also deemed sensitive, which is why it needed to be a part of the protective order that they fought about. So Trump couldn't reveal it. So he needs to get it from J6 and he can't get it from J6, and he should have been reviewing it earlier, but he never had access to anything that he can review because it's all sensitive, and by virtue of it being sensitive, it means it's not public. And it's 11.5 million pages of the sensitive stuff. Only a small percentage of that is not sensitive. So he really has no choice but to review the 11 million pages because it's not public. This is good stuff. And so they boxed themselves in, basically. So the judge, I think, is going to be stuck on this in many ways because it's really 11.5 million pages by their own admission, and Trump never had access to it. And it's sensitive because they fought. It's so sensitive, Judge. Make us a big protective order. Well, you got your big protective order, nor would he have known what the materials to review are, as the government did not have any pre-indictment explanation of its theory of the case, right? Let alone identify any information which purports to support those charges. Trump's defense says at the same time, the government has identified no good reason why it waited 31 months to seek an indictment. The notion that the government may, with all its vast resources, spend years investigating this case only to turn and demand the defense be prepared for jury selection in 4 months defies all notions of fairness. Years for them, couple months for Trump. He should have been investigating the January 6th Select Committee, but that was all public. But we also have 11.5 million pages of sensitive material that we can't make public. That's why we need a protective order. The defense says, without a doubt, the public has an interest in the prompt resolution of this case. Surely. However, as the Speedy Trial Act recognizes, that interest must yield to the public and the defendant's overriding interest in a just proceeding. The proposed schedule allows President Trump to defend himself fairly. The government's proposal does not. Accordingly, the court should adopt our proposed schedule. They say the complexity of this case warrants it. The large volume of discovery in this case is not happenstance, Your Honor, but it reflects the reality of this complicated and unusual case. There are hundreds of potentially relevant witnesses spread across the country. Many are current or former government officials, including with the DOJ itself. Events alleged in the indictment and which are otherwise pertinent likewise occurred throughout the country. Classified documents are at issue, as well as large quantities of search warrant materials that may be subject to suppression. File a motion to suppress that evidence. Whatever came after a bad search warrant should not be admitted as evidence. As noted above, President Trump will seek discovery from government departments and other witnesses, as well as pretrial subpoenas, and this may raise a host of other difficult issues for the court to resolve. These factors alone suggest this case is complex under the meaning of the laws and weigh in favor of a lengthier trial calendar. However, this case is not just complex or unusual. It's terra incognita, unrecognized ground. These protests at Capitol Hill aside, no person in the history of our country has ever been charged with conspiracies related to the Electoral Count Act. No president has ever been charged with a crime for conduct committed while in office. No major presidential party candidate has ever been charged while in the middle of a campaign, and certainly not by a DOJ serving his opponent. These and numerous other issues will be questions of first impression, requiring significant time for the parties to consider and brief and for the court to resolve. The proposed schedule provides that time. The court's government timeline does not. Consequently, the complexity and unusual nature of this case favors Trump's proposed schedule. They say the government also acknowledged that it considers materials that it got from the Congressional Committee and the Secret Service as material to this case. So if that evidence is missing, that's a problem. We know the Secret Service deleted those text messages. Uh-oh. We know the J6 committee seems like they deleted some evidence. Uh-oh. Many other government agencies may have information favorable to the defense as well. Wonder what happened to that. The government cannot pick and choose what sources of information are important to the determination of this matter. Justice requires that the defense be accorded the time to consider, request, and review all information material to the charges. And Your Honor, as the court stated in August 11th in our hearing, and as the government then agreed, this case should proceed in the normal course that our justice system prescribes. Explained above, normal course for a complex, document-intensive case like this is not to rush to trial, but a measured schedule that preserves the defendant's right to discovery and the right to raise motions. They say, indeed, the median time from commencement to termination for a jury-tried Section 371 charge is 29.4 months. Many times it's longer, many times longer than the government's proposed schedule. And this reflects only the median, meaning half of those cases take even more time based on their individual circumstances. 29.4 months, the median. Some go faster, some go longer. Likewise, the court regularly allows far more time than the government proposes, even in cases involving January 6th. You've done other cases where you've given us a lot more time. In other words, ordinary order then, Judge. We're not asking for anything special. We're not asking for anything crazy. We just want the ordinary order of court. That's it. Is adherence to the Constitution and the Speedy Trial Act, together with their assurances of fair and just criminal trials, regardless of the government's ill-placed desire to hurry this case to conclusion. And do you notice something we have not heard one time yet throughout this entire document? Election. Nothing. Nothing about election at all. Not a justification for postponement because of the election. In other words, don't continue it because the primaries are in January and that the election is in November. Nothing as a date there. It's only based on the amount of discovery, really, and the novel issues of law. They say that SIPA, the Classified Information Act, also controls some information in this case. These delays can be extensive. The government recently explained that they are unaware of any case with classified discovery that went to trial in less than 6 months. Court said, can you point Mr. Prosecutor to other cases involving classified information that have gone to trial following production of discovery in less than 6 months? He said, oh, so going to trial in less than 6 months? No, haven't seen that. Trump's defense says this case will be no different. Government acknowledges even uncomplicated SIPA cases involving very small numbers of documents with no substantive pretrial motions take a minimum of 8 months. It is therefore puzzling that the government would propose a trial date that the SIPA process cannot accommodate. We've got classified documents. There's a discovery process to get them. It takes longer than 4 months to do that. Our proposed schedule, conversely, accounts for SIPA and other issues that are going to pop up. They say another key factor in setting any trial date is the detention status of the defendant. So if you're in custody, the defense wants to go to trial quickly to get you out of custody. But Trump is not in custody here. There's no reason that this court should place the government's desire for a headline ahead of the interest of any detained defendant in this district who is awaiting trial, right? There are other people who are in custody who should go first. We don't need to rush this thing. Mr. Bratt previously led the DOJ's counterintelligence entity. He should know better. He's got, quote, extensive experience. He should know better, Judge. This is saying that Bratt is being a little dishonest here. He's being underhanded. He should know better, Judge. He's asking you to schedule a trial before he can even comply with the SIPA rules in most cases. The government's proposal also conflicts with other cases. Obviously, they are playing lawfare against Trump, and so here's the list. Other cases. If they want to schedule this thing for December and January, that's a conflict. Got a civil case in New York, 6-week trial beginning October this year. Another civil case, SDNY, 2-week trial, January 15th. Another criminal case, 5-week trial, scheduled by Alvin Bragg, New York. Big Fani Willis in Georgia has requested a March 4th trial date. That's also nuts. That will never, ever happen because her case is basically an analog of this case. It kind of mirrors the January 6th case. I don't even know how many documents she's got, but it's probably millions. A criminal case in the Southern District of Florida, also prosecuted by special counsel and scheduled a 5-week trial in Florida. That's the documents case. So they say President Trump must prepare for each of these trials in the coming months. All are independently complex. All will require substantial work to defend. Several will likely require Trump's presence at some or all of the trial proceedings and beyond trial. These cases will include numerous pre- and post-trial hearings that will invariably conflict with the government's proposed trial calendar here. As one example, a pre-trial hearing in the special counsel's Southern District of Florida prosecution is scheduled for December 11th, same day that they want jury selection to begin here. They say, Your Honor, without question, President Trump's obligations to diligently prepare for this case does not end because of other pending matters. However, the court may and should consider the practical effect of these parallel prosecutions and what they are going to do to Trump's ability to meet the extraordinarily brief deadlines that the government is proposing. Once again, the government's proposed schedule does not address these significant concerns. Our schedule resolves them, so you should adopt it. In conclusion, the proposed schedule appropriately balances President Trump's constitutional and statutory rights to counsel and fair trial with the public's need for promptness. The schedule is consistent with the ordinary order, resolves the conflicts presented by SIPA and other pending prosecutions, and so, Your Honor, accordingly, the court should determine that the ends of justice outweigh the interest of the public and Donald Trump that he has in a speedy trial, adopt the proposed schedule, and exclude time, meaning don't count all of the time between today and April 1st, 2026 against Trump. Respectfully submitted by Gregory Singer. And can we just pause for a moment and shout out Gregory M. Singer on a brilliant motion. Shout out to the rest of the team there. Also at Lauro and Singer, along with Blanche Law Firm out of Tampa and New York, doing some excellent work there. What an outstanding motion. And they left out, a lot of the same election arguments that he's running for president. And this is a political prosecution in the middle of a campaign, and we need to postpone this until after the campaign. You didn't hear about any of that at all. It was just straight to the facts, and they have boxed the DOJ in here in a very brilliant way. They dropped 11.5 million documents in initial discovery, and that is 8 Washington monuments. 8 full of documents, okay, physical documents. And now they're going to have to eat that. So that's going to be very interesting. Now, very excited about that, and I think that might have something to do with what Trump is doing here. He has canceled his voter presentation, probably because they have an extremely strong case here that there are discovery violations and that they have the due process and equal protection obligations to postpone this thing far. So he's saying, all right, strategy's changing a little bit, no problem. Says, rather than releasing the report on the rigged and stolen Georgia 2020 election on this Monday, my lawyers would prefer putting this, I believe, irrefutable and overwhelming evidence of election fraud and irregularities in formal legal filings as we fight to dismiss this disgraceful indictment by a publicity and campaign finance seeking DA, who sadly presides over a record-breaking murder and violent crime area called Atlanta. Therefore, the news conference is no longer necessary. Probably a good decision legally. Of course, I kind of wanted to see, just for the morbid curiosity, the battle between the courts and free speech, protecting the judicial integrity, the process, blah, 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 and Trump's ability to speak out about a corrupt process that really doesn't have any integrity in the first place. So I would have loved to see that. We might still see that. Hang tight to that. It might come down the line at another time. But we are turning to Rudy. Rudy, of course, is a co-defendant of Donald Trump, who has been charged with a crime in the same Georgia case, and he is out here roasting Big Fani. This clip came over from Patriots Are in Control. Says from Rudy, says that he's roasting Big Fani on his show. Here's what he said.
You don't think we could get doctors to say he's not mentally capable of doing the job? You could get a lot of doctors, as long as you offer them protection against being prosecuted by Fani Willis.
Yeah, Fani.
She'd probably do a RICO case against the doctor. She doesn't even know. I don't even think she knows what the RICO statute is. You know how many mistakes she made in that indictment? Do you know how she made it so much more possible to remove the case? Because she's so damn stupid. She didn't bother to read 28 U.S.C. 1442.
We'll take a look at it.
I had that in my file for 4 weeks. Said nothing about it because I didn't want to alert her. But she could have tailored the indictment to make it more difficult to remove the case. One example. I'll just give you one. I mean, it's over now, so it doesn't matter. She didn't have to put in all those other places. The minute she puts in all those other places, it becomes more of a federal case. Makes it an easier argument. Now, not critical. Probably could have won the argument anyway. She just made it easier. The job of a lawyer is to help your client, not to hurt your client. And the client's objective here is to unfairly prosecute and convict innocent men and women. Well, she made it more difficult to successfully prosecute innocent men and women.
Good.
And it's an outrage that the left wing in this country and the media and what stands and watches this, the former president of the United States have to go into a jail that the federal government finds inhumane and indecent. Of course, it's a crooked city. Is there anybody with common sense in Washington? And is there anybody with guts?
Not really, not in Washington. But so that's Rudy, and he makes a good point, right? 28 U.S. Code 1442. This is the same statute that Mark Meadows is referencing for his federal removal. And we'll, of course, take a look at the Mark Meadows removal, the order from the judge granting the removal hearing in another segment. But this is the summation of the code that Rudy's referencing. 28 U.S. Code 1442, federal officers, when they are sued or prosecuted. We've got this, a civil action, forget that, but a criminal prosecution, which is currently happening out of Georgia, that is commenced in a state court like Big Fani's, and that is directed against anybody who's one of the following, may be removed by them to the district court, the federal court, from the state court up into the feds, for the district and the division embracing the place where it is pending. It says the United States, if they're the subject, or any agency thereof, or any officer, or any person acting under that officer, right, of the United States in an individual or official capacity relating to under color of such office, the title authority, if they're acting under the president, who is the executive officer of the United States, they have the right to remove the case from Big Fani's court to the federal level. And so the cases are just looking brutal. And Trump and his defense are filing some good substantive motions. And even Bill Barr is agreeing that some of this case doesn't look so good. Here is what he said.
Meanwhile, the focus on the former president's legal cases, there are 4 big ones involving 91 charges, again, across 4 humongous criminal cases that could go on for quite some time, especially if the Trump lawyers have their way with trying to push.
All right, weirdo.
I'm not happy with the Georgia case. I think it's much too sweeping, much too broad, excessive case that make it look like people are piling on and being excessive to Trump and feed the narrative that he's being victimized here.
He is.
And I also think there's merit in the
Isn't
point.
this strange? He says the weirdest things. He's like, this case is so garbage and it's overbroad and it feeds the narrative that he's being victimized. And you're like, Bill, you just described him literally being victimized. Are we nuts? He just described an overbroad prosecution that is just not very valid and is upset that it feeds the narrative. But is he concerned about the actual prosecution?
In March, what the prosecutor is looking to do. It's right around Super Tuesday, but besides that, it's not nearly enough time. What do you think?
Well, I'm not happy with the Georgia case. I think it's much too sweeping, much too broad, excessive case that make it look like people are piling on and being excessive to Trump and feed the narrative that he's being victimized here. And I also think there's merit in the point that this is a case that I don't think is going to be triable before the election. It's just too sprawling.
Can any of them be tried before the election?
I think the two federal cases will be tried, and they are.
No way.
I think the responsible cases. They're far more focused.
Not with the 11 million documents there, Bill.
Will be tried before. The New York case is, obviously a political hit job, and in my opinion, it's a joke.
On his business dealings and everything.
Right.
Did you hear that? There's another hit job and another joke, but also there's a ridiculous narrative that Trump is being victimized. That's two. He just gave us two examples of himself where Trump is the victim of insane prosecutions, but that dang narrative, very pesky, don't know where that came from.
It was the payoff, the hush money. And I think at the end of the day, that may not be tried. I think it could just be pushed out because I think Bragg would be worried about actually bringing it to trial.
But even in the case of the one that you argue could be, that is Jack Smith's trial, he wants to get going, in January. I mean, right before the Iowa caucuses. I mean, should they be weighing the timing of either Super Tuesday in the case of the Georgia one or the Iowa caucuses in the case of Jack Smith's one? What?
It's all about the elections.
To some degree, they might accommodate, a few days here and there, but I don't think that should govern the schedule for pursuing these cases. You don't get immunity for 2 years in the run-up to an election just by saying, hey, I'm a candidate, you can't try me. These investigations have been going on for a while. Everyone knew about them even before he announced his candidacy. So if there's a chance to get it resolved before the election, it should be, because the American people should know these are crimes that involve, or potential crimes that involve, moral turpitude.
Now, busted, Bill. So, he's just in his own little bizarre world. Very strange state of affairs with that guy. But he agrees Georgia's garbage, New York's garbage, but Trump is still making this up like he's the victim of political prosecutions. I think he's wrong. I don't think any of these trials will go. Does he know that there's 11 million pages of documents out there? Not so sure he does. Of course, we'll continue to cover this amazing scheduling memo from Trump's team. We're going to continue to cover, my friends. Thank you for subscribing and following along.